Friday, June 12, 2026. A federal judge has stripped a sitting president of core executive powers while impeachment proceedings are still underway. This is not advice. It is not a recommendation. It is a binding order from a federal court. At 9:14 this morning, Eastern Time, U.S. District Judge Patricia Hernandez of the Southern District of New York issued a 38-page ruling. It was signed, filed, and immediately enforceable. Page 1, paragraph 3 states, "The court suspends the president's authority to issue executive orders, grant pardons, or make federal appointments until the impeachment proceedings currently before the House of Representatives are resolved." Think about that for a moment. Executive orders, pardons, and federal appointments have all been suspended by a federal judge while impeachment is still ongoing. Not after a conviction, not after removal from office. Right now, in the middle of the proceedings, there is no bond and no arrest, but what happened may be even more serious. A sitting president has effectively had the tools of the presidency removed from his control because a judge determined he could not be trusted to use them. The ruling lays out 47 pages of constitutional analysis, cites 31 separate cases, relies on 4 different constitutional doctrines, and reaches one central conclusion: presidential authority is not unlimited. When evidence indicates that a president may be abusing that authority during active criminal and congressional proceedings, the courts have the power to step in. That is now the official ruling, entered directly into the record. Most people are reacting to the headline, but almost nobody is reading the order itself. I did, and I want to walk you through exactly what it says. Start on page 4, section 2, titled Constitutional Basis for Judicial Intervention During Impeachment. Judge Hernandez begins with Article 2, Section 4 of the Constitution, the Impeachment Clause. But she does not rely on that provision alone. She connects it with the judicial authority granted under Article 3 and the President's duty under the Take Care Clause. 3 separate constitutional provisions are brought together to form one legal framework. In plain language, the President is required to faithfully carry out the laws. When evidence suggests he is doing the exact opposite, the courts do not necessarily have to wait for Congress to complete the impeachment process. They may act on their own authority. Page 12, paragraph 19, says that no constitutional principle requires the judiciary to stand by while executive power is being used to advance the same conduct currently under impeachment investigation. Put simply, when a president is being impeached for abusing power, the courts are not obligated to sit back and watch that same power continue to be abused while Congress debates what to do. That is the central mechanism almost nobody is discussing. So how is this different from Nixon? Nixon fought against subpoenas, and the courts ordered him to produce documents and evidence. That case was about access to information. This ruling is about presidential authority itself. Judge Hernandez did not order Trump to turn over records. She ordered him to stop exercising specific presidential powers. It is also different from Clinton. Clinton's case involved whether a sitting president could face civil liability. The courts ruled that a president could be sued while in office. That was a question about lawsuits. This case deals with the actual machinery of the presidency being restricted by judicial order. Then you reach page 22, the enforcement section. It states that any executive order, pardon, or appointment issued after the ruling is void, not temporarily blocked, not subject to later review, void, legally treated as though it never existed. But this decision did not suddenly appear out of nowhere. When you follow the record backward, every part of the structure was already being put into place. Let me show you how it was built. Go back to Tuesday, June 9, 2026, 3 days before the order was issued. President Trump was still exercising full executive authority, and White House counsel was publicly insisting that the president's powers were absolute and could not be reviewed by any court. Behind closed doors, however, something very different was happening. At 2:15 Tuesday afternoon, prosecutors filed a sealed 54-page motion titled Emergency Judicial Intervention During Active Impeachment. Nobody outside the courtroom saw it. It was entered under seal, received no media coverage, and produced no leaks. At 6:30 that evening, Judge Hernandez's chambers notified both sides that she would review the motion overnight. Overnight, not the following week, and not after setting a lengthy briefing schedule. By 8 o'clock Wednesday morning, the White House legal team had received formal notice. They submitted an emergency 29-page response at 3:47 that afternoon. Their central argument was straightforward. Federal courts have no constitutional power to restrict presidential authority under any circumstances, because the separation of powers forbids it. At 9:22 Wednesday night, prosecutors filed a 17-page rebuttal that had clearly been prepared in advance. They were ready for every argument the White House made. Each claim of immunity was answered with constitutional precedent that had already been researched. Every separation of powers objection was met with case law already included in the sealed motion prosecutors filed on Tuesday. By Thursday morning at 10 o'clock, the court held sealed oral arguments with 4 attorneys present. The hearing lasted only 22 minutes. Judge Hernandez asked White House counsel a single question. Does the president's position mean he is beyond judicial review, even when the conduct being examined is the very basis of an active impeachment proceeding? White House counsel answered, yes. Judge Hernandez gave no response. The hearing ended. At 4 o'clock Thursday afternoon, both sides were informed that a ruling would be issued within 24 hours. Then, at 9:14 Friday morning, the order came down. That was the entire 72-hour window. By the time the public learned about the decision, every argument had already been submitted, heard, and resolved. The ruling appeared sudden, but its legal foundation had been secured 3 days earlier. Now go back even further, because this is where the full pattern becomes visible. On April 14, 2026, nearly 2 months before the ruling, prosecutors filed a motion that almost everyone ignored. Case number 26-CR-4471, page 18, paragraph 11, stated that courts may restrain executive functions when the exercise of those powers directly interferes with proceedings designed to determine whether a president remains fit for office. That single sentence became the legal starting point for everything Judge Hernandez ultimately ruled on June 12th. At the time, almost nobody connected the two, but records later obtained through FOIA requests, along with filings that were eventually unsealed, show exactly what prosecutors were building between April and June. On April 14th, they submitted the initial constitutional framework, arguing that courts have authority to intervene during impeachment proceedings. On April 28th, the White House filed a motion to dismiss, claiming the president had absolute immunity from any judicial restraint. On May 6th, prosecutors responded with a 41-page brief, citing 23 cases and including 3 amicus briefs from constitutional scholars. That filing addressed every immunity argument raised by the White House, one by one. On May 14th, the White House submitted a second immunity brief with a new claim, that limiting presidential powers during impeachment would violate the presentment clause. 5 days later, on May 19th, prosecutors answered again, and the speed of the response strongly suggested the rebuttal had already been drafted. Footnote 37 on page 29 cited a 1974 Office of Legal Counsel memorandum concluding that judicial oversight of executive authority can be constitutionally permitted during congressional removal proceedings. I went back and read that footnote 8 times. The meaning did not change. That memo became a central pillar of Judge Hernandez's June 12th decision, and she cited it directly on page 16. Here is the through line. Prosecutors identified the constitutional mechanism in April, filed the framework, waited for the White House to present its immunity defenses, and then dismantled each one using research they had already completed. Every major White House argument had been anticipated weeks before it was formally filed. This was not reactive litigation. It was a constitutional strategy assembled piece by piece, motion by motion, over a period of months, all leading toward one ruling. But there is another side to this, and it matters. Trump's legal team, along with constitutional scholars who support their position, read the decision very differently. Their argument is not frivolous. White House counsel David Callaway, a former federal appellate judge with 22 years of experience in constitutional law, called the ruling the most dangerous act of judicial overreach in American history. His central position is that Article 3 gives courts the authority to decide legal cases, but it does not give them the authority to disable the presidency itself. Their strongest historical point is simple. No federal judge has ever removed executive powers from a sitting president. Not during Watergate, not during Clinton's impeachment, not at any point in American history. Under their interpretation, the constitutional remedy for presidential misconduct is impeachment and removal by Congress, not the suspension of presidential powers by a judge. And their most serious concern carries real weight. If one federal judge can suspend executive orders and pardons, what prevents another judge from suspending a president's authority as commander-in-chief? Where does that power stop? And who decides the boundary? A Georgetown constitutional law professor with 30 years of experience studying separation of powers argues that Judge Hernandez effectively created a new judicial power that does not exist anywhere in the Constitution. Courts can compel testimony. They can require the production of documents, but they have never, on their own authority, taken away the tools of office from a sitting president. Former Attorney General Richard Langford put the argument even more directly. He said the framers gave impeachment power to Congress specifically to prevent courts from doing exactly what Judge Hernandez has now done. In their version of events, prosecutors deliberately constructed a constitutional framework designed to bypass Congress and transfer authority to the judicial branch that it was never intended to possess. Some of the documents do support parts of that claim. The constitutional questions raised here are genuinely unprecedented. No previous court has claimed this exact power. At the same time, the record also shows that prosecutors developed a serious legal framework rooted in constitutional text and historical precedent. Both interpretations exist. I am laying out the evidence trail, and you can decide what it means. Now, I know what many of you are doing right now. You are completely locked into this story. Your heart rate is probably elevated. You may have spent weeks glued to political coverage, sleeping less, eating badly, and delaying that appointment you keep telling yourself you will schedule later. But this situation is not disappearing overnight, and your health cannot wait for a constitutional crisis to end. Care Health is free, and it connects you with healthcare options, screenings, and clinical trials available in your area. Whether you are dealing with sleep problems, chronic pain, or overdue preventive screenings, the process is simple. You fill out a short form with your date of birth, gender, and a few basic questions. It takes about 30 seconds, costs nothing, and carries no commitment. Care Health then matches you with relevant options near you. Click the link on my channel page or scan the QR code currently on your screen. Open your phone's camera, point it at the square, and tap the link. If you are already watching on your phone, tap the channel profile picture to open the channel page. The link will be right there. There is also a screenshot on screen showing exactly where to find it. Everything happening in this case will still be here when you return. Take 30 seconds for yourself first. Now let us get back to the case, because what happened next is where this becomes real. This is no longer one story. It is 3 separate stories unfolding at the same time, all moving and all connected. Track 1 is federal court enforcement. Judge Hernandez's order is already in effect. Any executive order, pardon, or federal appointment Trump issues at this moment is legally void. But the ruling can only be enforced if federal agencies agree to recognize it. That creates the first major question. Will the executive branch obey a judicial order that strips away part of its own authority? The key deadline is Saturday, June 13th. The White House must submit a compliance statement confirming that it will follow the court's order. If that statement is not filed, Judge Hernandez could hold the entire White House counsel's office in contempt. Track 2 is the congressional impeachment process. The House Judiciary Committee had already been conducting impeachment proceedings before this ruling was issued. Now there is a federal judge on the record stating that the president's conduct is serious enough to justify judicial intervention while those proceedings continue. That gives Congress new ammunition. The key date here is Tuesday, June 16th, when the House Judiciary Committee will hold an emergency hearing to determine whether Judge Hernandez's decision should accelerate the impeachment timeline. Several committee members are already demanding an immediate vote on the House floor. Track 3 is executive defiance. Trump's legal team filed an emergency appeal at 11:30 this morning, challenging the ruling, but Trump himself has remained completely silent. No press conference, no statement on social media. His staff is refusing to answer questions. The critical date is again Saturday, June 13th. If Trump issues an executive order or grants a pardon before the appeals court acts, he will be directly defying an active federal court order. At that point, this stops being a normal legal disagreement and becomes a full enforcement crisis. Here is how all three tracks connect. If track 1 moves first, and the White House refuses to file the compliance statement on Saturday, track 2 immediately gains momentum as impeachment pressure builds through the weekend. If track 3 moves first and Trump issues a defiant executive action, then tracks 1 and 2 are triggered at the same time. The court begins enforcement while Congress accelerates its response. These events are synchronized. Once one track moves, the others move with it. So what are constitutional scholars saying about a ruling like this? Former Solicitor General Catherine Wells, who spent 28 years arguing cases before the Supreme Court, believes Judge Hernandez did not create new law. In her view, the judge applied existing judicial authority to a situation no court has ever confronted before. She considers the legal reasoning sound, while acknowledging that the precedent could be enormous. A Harvard constitutional law professor who has studied executive power for 35 years sees it differently. His position is that the Constitution already gives Congress a tool for dealing with presidential misconduct, and that tool is impeachment. When courts begin suspending presidential authority independently, he argues, the constitutional structure itself has been changed. That should concern people regardless of political party. There are, however, several points on which both sides agree. The prosecutor's legal preparation was extraordinary. The constitutional issue is genuinely unprecedented. No court has ever asserted this specific kind of authority over a sitting president. And the decision has moved the country into completely new constitutional territory. The disagreement is over whether that territory represents a legitimate evolution of judicial power or a dangerous overreach that weakens the separation of powers. The historical context matters. In United States versus Nixon in 1974, the courts ordered a president to turn over evidence. That case was about tapes, records, and documents the president was required to produce. It was not about limiting what the president was allowed to do. In Clinton versus Jones in 1997, the courts ruled that a sitting president could face a civil lawsuit. That case concerned legal liability and whether a president could be sued while still in office. It did not involve revoking any presidential authority. Judge Hernandez's ruling is fundamentally different from both. She did not order Trump to produce evidence or defend himself in a lawsuit. She ordered him to stop exercising specific constitutional powers while the impeachment process continues. A former White House counsel who served under two different presidents explained the distinction in the clearest possible terms. Nixon was ordered to surrender his tapes. Trump has been ordered to surrender his powers. Those are not remotely the same thing. That difference is exactly why this case is heading to the Supreme Court. The only real question is not whether it gets there, but when. Here is what happens next, day by day. Saturday, June 13th. The White House faces its compliance deadline. Trump either confirms that he will obey Judge Hernandez's order or he does not. If the White House refuses to comply, contempt proceedings could begin immediately. Then, on Sunday, June 14th, an emergency hearing is scheduled before a three-judge appeals panel. The panel will decide whether Judge Hernandez had the constitutional authority to suspend presidential powers, and a ruling is expected that same day. The courts are moving quickly because nobody is treating this as an ordinary dispute. On Tuesday, June 16th, the House Judiciary Committee will hold an emergency hearing focused on one question. Does Judge Hernandez's ruling justify accelerating the impeachment process? Several members are already indicating that they want a full House vote before the end of the week. If the appeals court upholds the ruling, Trump's legal team is expected to file an emergency petition with the Supreme Court on Wednesday, June 17th, likely within hours of the decision. Then, on Thursday, June 18th, the Supreme Court could hold an emergency conference to decide whether to temporarily block Judge Hernandez's order while the case receives fuller review. This is the critical moment. If the court grants a stay, Trump's suspended powers would be restored for the time being. If the court refuses, the ruling remains in effect and enforcement continues. From here, there are three possible outcomes. The first is that the Supreme Court upholds the ruling. In that scenario, presidential powers would remain suspended during impeachment proceedings, creating a precedent that could shape the presidency for generations. Every future president would know that courts may be able to intervene while impeachment is underway. The second possibility is that the Supreme Court overturns the decision. That would establish that the judiciary cannot strip a sitting president of executive authority, and that impeachment and removal by Congress remain the only constitutional remedies. Judge Hernandez's entire framework would be rejected. The third outcome is a narrower ruling. The court could decide that judges may intervene in certain limited circumstances, but not as broadly as Judge Hernandez ordered here. That would create a partial precedent and almost certainly lead to years of litigation over exactly where the constitutional boundary lies. Before this week, no federal court had ever claimed the power to disable specific presidential authorities. After this week, whatever the final outcome, that question is now permanently part of the constitutional debate. It cannot simply be erased. That is the new reality. As things stand right now, Judge Hernandez's order remains active and enforceable. Trump's authority to issue executive orders, grant pardons, and make federal appointments is suspended. Any such action taken after 9:14 this morning would be considered legally void. Trump's attorneys filed an emergency appeal at 11:30 a.m., and the appeals court hearing is set for Sunday, June 14th. No stay has been granted, which means the ruling continues to control unless a higher court intervenes. The White House compliance statement is due Saturday, June 13th, and there is still no indication whether the administration intends to obey the order or openly defy it. The House Judiciary Committee's emergency hearing is scheduled for Tuesday, June 16th, with a possible impeachment vote by the end of the following week. Several members are already pressing for a faster timeline. If the appeals court leaves the ruling in place, the Supreme Court is expected to consider an emergency stay as early as Thursday, June 18th, likely within 24 hours of receiving the petition. Trump has still not addressed the public. There has been no press conference, no social media post, and no direct statement. His legal team is handling all communication, while White House staff continue refusing questions. Judge Hernandez is monitoring compliance from her chambers. White House counsel David Callaway is leading the emergency appeal. House Judiciary leadership is coordinating over the impeachment schedule, and the Supreme Court is watching the case develop from above. What remains unknown is whether Trump complies on Saturday, whether he issues an executive action in defiance before the appeals court rules, whether Congress moves before the courts complete their review, and whether the Supreme Court temporarily blocks the order or allows it to remain in force. 3 separate tracks are still moving at once, each connected to the others, and all of them are approaching decisive moments within the next 6 days. This story is still developing, and I will continue following it in real time. And for those who have not checked it yet, the Care Health link is still available on the channel page. It takes about 30 seconds, it is free, and it may help you find options relevant to your health. Take care of yourself.